Good afternoon, everybody. This is Lucas. I am speaking. I am opening here these words for a brief seconds. This is the ninth Rio Pre Moot. It's an honor to be here. It's an honor to be on the side of these people that have done an amazing job to organize everything. And we'll start today with a presentation of the case and some discussions on it. So let's start. Joaquin is going to introduce some words before Bernard, and then we'll have our event. We we hope everything goes fine. We'll be at your disposal to help in anything you need. And so good luck to you all. It's always an honor to be here. Joaquin, it's with you now.
Thank you, Lucas. Thank you, Bernard, Isabel, Daniel. We are the organizing committee of the ninth Rio Pre Moot, and thanks, Marcos Atankis, that's our special speaker today. We are in very difficult times. You know that Brazil is in the peak of the COVID-19 second wave of COVID-19 pandemic, but nonetheless, we were able to organize Rio Pre Moot, first time completely online, with a record of universities, 29 universities, more than 200 arbitrators, and for the first time with a series of events broadcasted through the YouTube. So we start here with Marcos, Bernard, Isabel, Daniel discussing the case. We're going to have tomorrow the classifying rounds. The general rounds of Rio Pre Moot not broadcasted, but the announcement of the finalists is going to be 8 p.m. Brazil time, Saturday, tomorrow, and the quarterfinals, semifinals, and finals that will take place on Sunday will all be broadcasted through YouTube. I think that's the first pre-moot that will broadcast the quarterfinals, semifinals, and finals. So we are making history here, being able to continue this very important tradition of the pre-moot, spreading the word of CISG international arbitration. So without further ado, I pass the floor to Bernard, who will share the next panel. Thank you all. I hope you follow not only this event, but the announcement of tomorrow and the quarterfinals, semifinals, and finals on Sunday. And good luck to all the universities.
Thank you, Joaquin. So let's begin. First, it is an honor on behalf of all the organizing committee to welcome all 29 universities that are participating in the 9th edition of the Rio Pre Moot. You have received your emails and schedules previously, but I remain available for any doubts. You have my contact number and telephone. Without further ado, I would just like to present the 3 panelists of today, beginning with Isabel Miranda, one who I'm proud to say is the mother of the Rio Pre Moot, that gave the idea of the Rio Pre Moot and executed the first years of the Rio Pre Moot. She's a PhD in international law that coached the team for the University of the State of Rio de Janeiro for 10 years, alongside myself and Daniel Grambal. Together with her is Professor Daniel Grambal, who's a professor at private international law at the University of the State of Rio de Janeiro, and coaches the team for the University of the State of Rio de Janeiro since 2010, so around 10 to 11 years now. And last but not least, Dr. Marcos Altenkirch is a senior associate at Baker McKenzie, originally from Germany, Frankfurt, but now currently working in the London office of Baker McKenzie, where he handles exclusively international arbitration cases. Marcos actually took part in the Vismut 16 years ago, and it was there that he discovered his passion for international arbitration. He coached a few teams for many years, has published commentaries on the CSG, a PhD dissertation on arbitration, and is ranked as a future leader in international arbitration by Who's Who Legal. So thank you all for being here. It is an honor to have these panelists today. We hope that this is the 9th, but not last, edition of the Rio Pre Moot. We hope to continue this tradition for many, many years. So without further ado, I pass the word now to Dr. Marcos to begin our panel today. Thank you.
Yeah, thank you very much, Bernard. Going to share my presentation. The This Moot Problem, a Practitioner's Perspective. That's the title of today's presentation. But before I start with that, I have a question to all students, to all listeners. Who of you has a driving license? I have one. I can see now here in the Zoom call a few hands. I can't see you on YouTube, but you can see my next slide. You know these people, most of them. They are Formula One drivers. This is my next slide. This is the racetrack of the Grand Prix in Monaco. And now I want to ask you, especially those with the driver's license. Imagine you are asked to present in front of Formula One drivers, a group of Formula One drivers on how to best drive on the racetrack of Monaco. How would you feel? That's how I feel today, or that's how we feel today, presenting on the This Moot problem, because you students, you are the Formula One drivers. You have studied the This Moot problem for 6 months, non-stop. I have just read it once, I have to admit, so ignore my ignorance. However, before you log off, I might have to add a few points to my example, because Isabel, Daniel, and me, we are not the occasional drivers, one could say, but we're the trusted advisors of Lewis Hamilton and his peers. Okay, and for that reason, I would like to dive in to the topic of today's presentation, a practitioner's view on the This Moot problem. So what is the practitioner's view? That's actually the next problem, the next issue, because I'm a passionate lawyer, I'm a passionate practitioner, and well, it depends. My view depends on who pays me, yeah, and who retains me. If I'm retained by the claimant, I'm clearly of the claimant's view. If I'm retained by the respondent, I'm of the opposite view. So I thought at least I will today play the devil's advocate. And I prepared a little survey to make this presentation interactive. And I would like you to go to use your mobile phones now, please. And please go to menti.com. Go to menti.com, you see it here on the slide, and then use this code. Yeah, you can now do what you usually shouldn't do if you hear a presentation. Use your mobile phone and play with it, and then you will see a question that will look very familiar to you. I can see the first participants have found it already, and then the question is: should Ross Pharmaceuticals be joined to the arbitration proceedings? Let's see. We now wait for a few results to come in. 3 people voted. That's a close race. Okay, I can see how many people are watching live. So I will wait for half, or yeah, at least a few. Yeah, a few more. We wait for a few more votes. Votes are coming in. Oh, we have 21 votes now. It's a very close race. My goodness, I can't believe it. 26, 50-50. Yeah, but it's a good sign for the drafters of the moot, or the drafters of the This Moot problem, if they prepare a problem that is very even, level playing field. Okay, 30 votes and 50-50, 31. I would say we wait for we wait for 2 more, I would say. Come on, 33, and then we start with a discussion amongst us. 33, there we go. Okay, so the majority believes that Ross Pharmaceuticals should be joined to the arbitration proceedings. Can you imagine it? I have to say, I respectfully but strongly disagree. Yeah, and that is for 3 reasons. And now coming really from a practitioner's view. The first one, and you won't be surprised to hear that, and that is for me the crucial issue. There is simply no consent. Yeah, there is no consent. Ross Pharmaceuticals does not want to join the arbitration proceedings, and Ross Pharmaceuticals hasn't signed an arbitration agreement with claimant. And Ross Pharmaceuticals never agreed to join a tripartite arbitration with or like here with 4 parties even. And there is not even a contractual relationship with claimant, and therefore I can see no basis to join Ross Pharmaceuticals, really no basis at all. And I don't understand how 53% of you think that there's a basis to join Ross Pharmaceuticals to this arbitration. And the second point, it's maybe as important as the first one with a lack of an arbitration agreement, is it's simply too late now. It's too late because the tribunal is constituted. Sorry, if the party is joined perhaps before the filing of the answer to the request of arbitration, I could imagine joining a third party and then giving the third party the chance to engage in the constitution of the arbitral tribunal. But now it's too late. The tribunal is constituted, and Ross Pharmaceutical can't be forced to accept that constitution of the arbitral tribunal. And I think no practitioner, no arbitrator in practice would really do that. And that would be also an unequal treatment of the parties, because Ross Pharmaceuticals can't participate in the constitution of the tribunal. And the third one is also quite obvious, and I've seen that in practice though as well, that a very important consideration is whether it helps the efficiency of the proceedings. And here Ross Pharmaceutical is a hostile party, and no reasonable, sensible arbitrator would join a hostile party to the arbitration that could completely derail everything. And Ross Pharmaceutical will have to be given a chance to respond to all the arguments, to all the briefs. That will cause severe delay. I can see you nodding, Isabel and Daniel, so you agree with me.
Would you like to start? Because I actually agree. So you can counter him, and then I can counter you, okay. And then I'll be the last one standing.
Okay, good. I don't agree, Marcus. Well, I could agree if I was well paid, but for the present presentation, I don't agree with you. And I understand your arguments, but I think that we could have maybe three counter arguments. The first of all is that the Swiss rules in Article 4, paragraph 2, awards the tribunal broad discretion to join third parties. It is true that Ross Pharma is not part of the same arbitration agreement yet. It is also bound by a Swiss rules arbitration agreement. So I think one could maybe argue that by providing for a Swiss rules arbitration agreement, it has consented to being joined in any proceedings under the Swiss rules, as long as the circumstances so command. But that would be maybe one first counter argument. The second argument about the arbitral tribunal, this is very tricky, and I think I think you're right to point out that might be a problem. Because Ross Pharma has not participated in the constitution of the arbitral tribunal. However, and I think that might solve the problem here, is that both arbitration agreements provide that the chamber will appoint all three members of the arbitral tribunal. So one could argue that Ross Pharma never really had the right to appoint itself an arbitrator because it had delegated that power to the chamber. Although it is true that it would be joining an ongoing arbitration, and timing might be a complicated issue. And the third argument that you brought, when it comes to efficiency, this is also a very good argument. But I would argue that it would be more efficient, not for the proceedings itself. I agree that joining a third, maybe hostile third party, may make the proceedings a bit more complicated than it would have been without it. However, if we think about efficiency in solving the dispute as a whole, it might be sensible to have all involved or potentially involved parties in the same proceedings to have it solved once and for all. That would be my three maybe arguments in favor of the joinder.
I'd like to close up because usually when this kind of issue arises, the students are very perplexed. They're like, but is it possible that Ross Pharmaceuticals wouldn't be joined? What if there was, dissenting decisions? Should another arbitral proceedings arise with Ross Pharmaceuticals and etc.? And they are quite surprised to know that no, there is something actually called consent. If the party did not consent, the claimant did not choose to raise claims against Ross Pharmaceuticals. They're not there. They have not agreed to be there. So yeah, that could definitely happen. We could have possibly two arbitrations in course side by side. And also, on the other hand, when we think about the client, neither Ross Pharmaceuticals signed the arbitration agreement with the claimant, nor claimant has. So it would be a case, if it were a real case, that maybe the representative of Ross Pharmaceuticals or claimant would be, actually, is it possible just because both arbitration agreements are the same and all the other arguments we saw here, is it possible that I never signed an agreement with this person? And the answer is yes. And of course, that's why this issue is presented to you in the Bismuth, because in a real case, it could go either way. But Marcos is correct. I was nodding because I believe my personal view on this issue would be more in the sense of not joining Ross Pharmaceuticals. In this case, this does not mean a general opinion, of course.
Okay, I think we agree to disagree on that. I was just wondering whether it really, obviously, if there was an ICC clause in the agreement between Ross Pharmaceuticals and Respondent 2, we wouldn't have that discussion at all, because it's obvious that it's not possible. But even if you have an agreement on the Swiss rules, it doesn't give the tribunal consent, like it doesn't give the tribunal jurisdiction, I find, over Ross Pharmaceuticals, because they're just not member of the same party to the same agreement, to the same arbitration agreement. Like the arbitration agreement might be phrased in the same way, but there is simply only an agreement between two parties, between claimant and Respondent 1. And Ross Pharmaceuticals is not a party. Of course, they could agree to it. If everyone agrees, then we have a new agreement. Then we have a new arbitration agreement, and then the tribunal has jurisdiction. But if they don't agree, I don't see how having the same arbitration agreement, which is between different parties, even if it's phrased in the same way, can give this tribunal jurisdiction. But I understand that one could be of a different opinion, and Daniel, congratulations! Actually, that you even convinced more people while we were discussing. More people joined the yes side than the no side. So,
but I would have, if we could, I would have just one last argument, but then in favor of the no. Maybe if I could just briefly switch heads while we were talking, something came up to my mind. Even assuming that the tribunal would have jurisdiction, let us assume it has jurisdiction and that it could, in theory, join Ross Pharmaceuticals. Should it do it? Because I think this is a very bad case to test Article 4, Paragraph 2. Why? Because claimant is merely asking a declaratory relief that Article 42 of the CISG was breached. And there is a very good argument, and I know there is opposing arguments on that point, but there is a very good argument that for Article 42 of the CISG to be breached, one would only need the potential of a claim being brought, however meritless that claim might be, meaning that even if respondents prevail over Ross Pharmaceuticals, let's assume that respondents prevail over Ross Pharmaceuticals. This doesn't mean that claimant, in our case, cannot prevail as well, because we had a claim, even if meritless. So I think that if we pass this, the jurisdiction argument and the consent argument, and we move to the circumstances of the case, then I would be inclined to think that claimant is right, because the tribunal doesn't need Ross Pharmaceuticals to be joined in order to decide the claim as it has been brought. But maybe we should move forward unless I move.
I know. We move to the.
Or I'll change again my mind. So it's.
Let's see. Let's move to the next question. This is the Swiss rules. So everyone back to your mobile phones. Remote hearings or not? Let's see whether we have again a close call or this time a clear vote. Again, that's the website, mentai.com, and the code you can see here, 44933612. Okay, I think we have a clear vote on that issue, and I have to say I expected it. I expected that our Formula One drivers haven't read the problem properly and haven't seen the parties' agreement on that issue. So I prepared a slide to show you the relevant parts of the problem that you should look at, and at least what we had 18% of the participants, they looked at the right section. So for me, as a practitioner, it's clear that we have a party agreement here. We're dealing with a scenario that the parties have dealt in their arbitration agreement, and they say the arbitration agreement stipulates hearings shall be held. Hearings shall be held. And then you might argue now hearings that could also be an online, a remote hearing, that's also a hearing with the definition of hearing that might suit your argument. And I would agree if the arbitration agreement would stop there, but it says hearings shall be held in Danubia or in Oceanside, the respondent's place of business. And a virtual hearing can certainly not be held in Danubia or in Oceanside, but a virtual hearing would always be online. So me as a practitioner would clearly say that we have a party agreement on the issue, on the relevant issue, whether we can have a hearing in in Danubia or whether we can have a hearing online. And it's also very clearly phrased, shall be held. So for that reason alone, I would never, as an arbitrator, like schedule a remote hearing on the relevant issue to examine the witnesses and the experts. But even if you were not to follow that argument, even then, as an arbitrator, I wouldn't schedule and provide for a virtual hearing, because, well, I have an obligation to render an enforceable award. And while it's not crystal clear that my award will be set aside and can be set aside in Danubia, the seat of arbitration, there's a very, very high risk, because the courts in Danubia, as we all know, they stated that unless you have an express agreement on the admissibility of virtual hearings, it's inadmissible. You need an express empowerment, as you have nowadays in the ICC rules or in the LCIA rules or in other rules, where it's expressly provided for. In the Swiss rules and in our arbitration agreement, there's no such express admissible or provision for the admissibility of virtual hearings.
What do you think?
Well, I'm afraid I'll have to disagree. Where are we now? Where are we having this hearing, this event? We're having it online. Isabel and I were in Rio de Janeiro. Marcus, you are in London. Bernard is in France. I'm kidding. He's in Rio de Janeiro as well. So where is a virtual hearing held for legal purpose? Where is a hearing held? I think that one could argue that a virtual hearing for legal purpose is held at the place of arbitration, which is a legal fiction. I know that the place of arbitration need not be a physical place. It's just a legal a legal pinpoint. So maybe we could argue that the tribunal can respect, even if the parties had derogated the Swiss rules and provided for hearings either in those two places, maybe we could argue that a virtual hearing would still respect the parties' agreement, because one could, at least as a legal fiction, say that we are having the hearing at the place of arbitration. That would be maybe my first argument. And I think that's a threshold question that we should answer, whether the parties have derogated or not and provide for physical hearings. But let's assume that they have not. Let's assume that there is no agreement on having or not a virtual hearing, or even if you would agree that a virtual hearing can still take place in Vindabona, that's the seat of the arbitration. Should the tribunal order a virtual hearing? And then I think that the arguments against a virtual hearing are based on very thin ice, because the maybe time zone difference, that's a serious issue, by the way. It's a serious issue, because there is a huge time zone difference between the parties, meaning that it inevitably one of them would have to argue and work throughout the after midnight and maybe during the early hours of the morning. My question is, does this amount to a violation of due process? Having one party having to argue and defend itself and present the arguments during midnight, is this sufficient to say that due process would be violated? And I think that the questions about hacking and data security, with all due respect, I think that's a concern, but that's manageable. I mean, especially because the parties have exchanged memoranda. In the problem, they have exchanged emails. The memoranda have been submitted to the tribunal by email, and the parties will be having the first hearing virtual. So this means that in a way or another, either there is no serious concern for both parties, or the tribunal has arranged the proper measures to be adopted so that the confidentiality of the arbitration and the security of the hearings would be protected. But I just conclude, I think that the most important question, first of all, is whether the parties have agreed or not that only physical hearings could be held. Because if your answer is yes, then the tribunal, unfortunately, has no other choice but to comply. I don't know what you think, Isabel.
Well, I think in this case, respondent's job is definitely more difficult. I think the majority view here in the poll is the majority view in arbitration, would be the majority view in arbitration practice. Something I would like to ask you, because of course in the following days we're going to be arbitrators in the Rio Pre Moot, and I have seen teams arguing that of course moot is for claimants, of course. Of course, we can hold hearings remotely because look at us now. We are conducting now a remote hearing. What is your opinion? Because I'm a bit concerned that the students are, I don't know, taking a peek behind the magician's curtain. You know what I mean? Maybe, maybe this is something we have to do because it's the moot. I'm not sure if that can be a legal argument, especially because claimant has a lot of persuasive arguments. I'm not sure if this should be something that will help them. What would be, you're coaching the team, what would be your advice to the team in this regard?
My advice would be always to follow your team's strategy. And at the end of the day, see what your coaches and your team think. I mean, there are very good arguments both sides. I think that to play it safe, and I think that sometimes playing it safe on the moot is very important. I would concede that we might have, that respondent is not opposing to any virtual hearing, but just that hearing where expert witness will be heard. Meaning that I think a team might want to already concede that respondent problem is not with virtual hearings at all, but with that very important hearing where I think experts will be heard and really the merits of the case will be discussed, and not just oral arguments by lawyers. Probably respondent will want to have, I'm not sure, an expert explaining how vaccines and if malaria and comparable infectious disease is similar or not to COVID. So I would, this is a strategic decision, but I think that sometimes, and the problem is so full of tricky parts that I think the respondent could begin conceding that we don't have a problem with virtual hearings at all. I mean, in general, it's just that very special hearing where the tribunal will be briefed about very sensitive and complex technical stuff. But that's what I think that our team is doing. At least I think so.
My 2 cents are, apart from the fact that I anyways don't agree with claimant's position, but apart from that, I also don't like that argument particularly well, because yes, the parties have simply specifically agreed to hold this hearing virtually. So I think claimant has other arguments. And I just wanted to comment on your point when you said the real issue is with virtual hearings is actually the time zone. And the question is whether this amounts to a due process violation. And I agree. In fact, from having done arbitrations, even if they start at 8 o'clock, you feel like jet lagged somehow, even though you haven't been in a plane. You have to get up very early. You might even want to speak to the client before the hearing. You might want to meet with the witness and tell the witness what to say. Little joke, of course, but you want to check the logistics, and it means getting up very, very early in the morning. So I don't feel as fit if I start the hearing at 8 or even earlier, than starting it at 9 or 9:30. So that's really a concern, I would say. And at night, it's the same thing. I might even prefer it in the evening, but still, it is an issue. And with witnesses, from the a practitioner's view, I don't see the concern, or I, at least in the cases that I've had, I didn't have the concern that the witness was influenced or somehow that cross-examination was less effective with the witness being sitting in front of the computer and being at home. But still, I feel like the atmosphere is a different one. It's more tension. It has more momentum if you have a witness and an expert in an in-person hearing. Whether the result is a different one, I don't know. But it deprives the party of something. If one party really insists on that, on that hearing and the day in court, it's questionable whether you can take that away from that party, whether it's in the discretion of the tribunal. But we don't have to discuss that, because here, as you say, hearings shall be held. We have a clear party agreement. Okay, shall we move to the issue 3?
Yes.
Let's see how much we have to discuss here. But let's hear first from the students. Is the CISG applicable?
It changes so fast, right?
Okay. I think we have, again, a relatively clear result. CISG is not applicable, you're saying. You are, again, unfortunately wrong. It is clearly a sales agreement. Why do I say that? Actually, I have to admit that I haven't had that case yet as a practitioner. So not sure whether this is now a practitioner's view. Let's start with the issue that we all agree on. We agree, probably at least, on the standard that we have to apply. What is the preponderant part? Yeah, what is the crucial part of a contractual relationship? And for me, it's clearly the purchase, the purchase relationship. And why do I think so? Well, you might now discuss the upfront payment, whether this is a license payment or a purchase agreement, and what the characteristic of that upfront payment is. We could discuss that now for an hour, but I think it's not relevant. Come on, what the parties intended, it wasn't sure, but what the parties intended was a long-term relationship, obviously, a contractual relationship, and a successful contractual relationship. And if we then look at the commercial terms are quite clear that over time, when claimant purchases these cells, claimant actually pays double the amount for the as a purchase price than as a royalty. So it's quite clear to me that the purchase obligation, or the purchase price that is paid, is the preponderant part of that contractual relationship. What do you think?
Oh, Marcus, again, I think you're wrong. No, I'm kidding. I think that we should first begin where we should always begin, is that reading the contract. And I think that the contract gives a lot of signs that the essential part of it and the idea, that the idea behind it and what the parties wanted to structure with the contract is not merely in the sales of goods, but rather a more broad cooperation agreement in the development of the vaccine. So, I'm not only saying, not even focusing on the names that the parties have given themselves, licensing, licensor. This is not irrelevant, but that's not all of it. If we read the scope, if we read clause 2 of the agreement, and it reads scope, and if I may just read the first lines, 4 lines, it says, this agreement governs the terms and conditions of what? The collaborative activities with respect to GOR at chem vectors for the indication of infections and non-infections, respiratory diseases such as inter alia, the responsibilities and activities to be performed by each party under the research plan. There is even a research plan. And then it goes on, scope, rights granted, blah, 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 research, development, and there is not in a single word, that only at the end, at the very last 3 words of the clause, that one reads, as well as potential further purchases. So I think that by the scope of the agreement, it is telling us that the parties wanted to structure more than just a framework for further sales, but rather a collaborative agreement for the purpose of research. And there is the obligations of the parties goes, there is a lot of exchange of information and data between them. So I think that if we look at the essentiality criteria, maybe I think that a respondent would be right. However, if we look at the preponderant part based on the value of the elements of the contract, then I think that it's more likely than not that the sales element would prevail. I know that there are a lot of uncertainties and the calculation depends on the amount of the hex cells that will be bought. But if we assume that we are in the middle of a pandemic, I think it will, and that the vaccine is on phase 3 of the research, so I think that it's more likely than not that there will be a lot of sales of goods going on. So again, I think that depends on the criteria that you use. I think one could argue that it is or it is not the sales of goods. But on my feeling, but that's just feeling, it's not a legal argument, but it's a good compass. My feeling is that this is not just a sales agreement, because I think that it is not even a sales agreement, it's just a framework agreement for further sales. So even if you would ignore the license obligations and all that stuff, then this might not even be a sales agreement because it just settled the framework. You don't have the quantity of the goods that will be sold, just the value. But that's my first impression.
No, because of time restraints, I think we should move on, especially because I don't want to say that the applicability of the CISG here is going to be quite difficult. We are all studying the CISG students, please, you know, these agreements are out there. Maybe our knowledge will be, you know, useful. So it's good that the CISG covers absolutely everything.
I agree as well. The more, the merrier.
Okay, then let's move to the last issue and the last discussion point for today. Do we have a breach of Article 42? Or do we have non-conforming goods?
Do you have the CSG here as well?
No.
Okay.
This is a close one again, a close race. I have to wait a little bit longer to see what my view is.
Just open Article 42.
Okay, it seems yes is winning. So I'm of the opinion that there's no breach. There's certainly no breach of contract. And it's very quick. It's a very quick story, to be honest, because Article 42 is not even applicable. The parties derogated from Article 42. So we don't need to discuss now, is Article 42, for example, different from many other laws in that Article 42 also allows or makes the goods non-conforming if there's a mere claim of a right, or do you really need a right? We don't need this discussion because we can focus on the contract. The parties have stipulated. They made like an agreement on the specification of the goods. So they derogated from Article 42, and they agreed that you need a right to assert any claim, a right to assert, and a right to assert a claim you don't have if you're not entitled. If there's no overlap of the licenses, then you don't have a right to assert a claim. So in my view, Article 42 is not relevant, only the contract, and the contract is narrower than Article 42.
I'm afraid I'll have to disagree with you again. I don't think that we can infer that the parties have derogated Article 42 by the contract. There is no indication that they wanted to narrow the guarantee that Article 42 provides for the parties. And then let's say, assuming that Article 42 is applicable, then things become very, very complicated, and I think one would have to be very analytical. To begin with, had the buyer, meaning claimant, to know about the quotation claim of the Ross Pharmaceuticals, and now I'm thinking about Article 42, paragraph 2A of the CSG, that provides that the obligation of the seller here would be respondents. The obligation of respondents under the preceding paragraph does not extend to cases where, letter A, at the time of the conclusion of the contract, the buyer knew, and I don't think that one could argue that the buyer knew, or could not have been unaware of the right or claim. So I think that one could argue that there is constructive knowledge, at least the claimant should have known about Ross Pharmaceuticals' claim, not least because the word was out in the market. We had at least 2 newspaper articles circulating among the players or in that field, and I know that claimant had canceled its subscription to the magazine, but it's all right. But then one could argue, shouldn't he then maybe he had the duty to inform itself of what was going on the market, at least through other means. So I think that, and I might agree with you, Marcus. I'm kidding. I think that, but for other arguments, not because
for other reasons. Yeah,
other reasons. I think that because of Article 42.2, and because I think that claimant should have known, ought to have known, by the time of the conclusion of the contract, that there was another player called Ross Pharmaceuticals that might eventually had a claim, even if meritless. I'm not discussing if Ross Pharmaceuticals' claim has merit or not. I'm just saying that the existence of this quotation claim, I think that claimant should have been unaware by the time of the conclusion of the contract. So at the end of the day, I think I agree with you. I think
Yes, I think we are getting close to the end of the presentation. I'm not sure if we should maybe give people on YouTube the opportunity to maybe ask one or two questions. I'm not sure. Lucas, Bernard, how would you like us to proceed?
Bernard, well, let me speak then. Well, the camp is going to start at 2 p.m. The information that I have here is that everything is already set. So Isabel is going to be one of the practitioners, one of the teachers that's going to hold the event. So we still have 8 minutes. Well, I think that you can, if the students, if the participants want to make questions on the YouTube, please feel free. But as for the organizing of here the Abertura, I think that we can start to go to an end so that people can organize themselves to start the camp.
Okay.
So,
Sounds good.
I think I just asked on YouTube if anyone has any questions. I'll leave 30 seconds for students to make it. If we have no questions, then we go to our closing. Just a minute then.
Yeah, let's just consider that when we speak here on Zoom, there's a 20 seconds delay to the YouTube. So we need to wait a little.
Okay.
While we wait, I would like once again to stress to the participant teams that are watching, if you have not received an email regarding the information to access the general rounds yesterday, please contact me. All emails have already been sent. So send an email to riopremoot@gmail.com or call me on the cell phone I already made available. I will be at your disposal for any doubts concerning the general rounds. So far, we do not have any questions, so I think we can proceed to end the opening of the 9th edition of the Rio Pre Moot. I'd like once again to thank Marcus, Isabel, and Danielle for the insights given, Joaquin and Lucas for the collaboration on preparing the Rio Pre Moot, and particularly all coaches, team members, and arbitrators, without which the Rio Pre Moot would not occur. So thank you everyone. We actually just received one question, so I think we can answer it and go to a closing. Guilherme Cartacho is asking, do you believe the future and conditional obligations for vaccine sales should be considered or not when defining the economic preponderance?
I think you addressed a little bit this issue, the future purchase.
Mm-hmm. Do you want to answer that, Marcus, or should...
Well, I'm happy to go first. Maybe it's because I'm not so deeply in the problem. I'm not sure whether I like all these nitty-gritty details about like the probability weightings and the calculations of the numbers, and I would more go into the overall picture. You know, I have more the meta view of everything, and for me the meta view is, well, both parties wanted that to be a successful relationship, and both parties intended it to turn out into, or turn out to be a purchase relationship, a sale and purchase relationship in the future, be that like on the conditional obligation to buy that or not. I wouldn't go into these details. That's my view.
Yes, I think that there are teams, even when they are arguing as claimants, that they concede that using the conditional obligations and the future sales is impractical, and then just move on to the essentiality criteria. But I personally, I do like to explore the table that we have at the end of the case at page 59. Because those are calculations that the parties made themselves together at the very day the contract was signed. So, and I think that we know now that only by a catastrophe, claimant will not buy enough hex cells so that the royalties will be higher than the sales element. What I mean is that in only a very small fraction of circumstances, the royalties will be preponderant. I don't have the exact number in my mind now, but we would need claimant to fail miserably in its researches for the royalties to still be preponderant. Then so I think that, but the problem is that it might be tricky in 6 or 4 minutes to go through all those numbers, because you need time to explain to arbitrators how the math works. And lawyers are usually not very good at numbers. So I think that it might be a strategy just to jump the conditional obligations, not because I think that there is a good argument to be made based on them, but because it might take you a lot of time to explain it to the panel. But so that would be my answer.
Thank you very much. In the interest of time, and as Isabel has to begin her classes at the Rio Pre Moot camp, so we are going to close now this opening ceremony. Once again, I thank you, all of you, for hearing us. I thank all the panelists. Thank you, Marcus, Isabel, Danielle, Lucas, and Joaquin. And see you at the general rounds or at the camp very soon. Thank you very much.
Thank you.
Good luck to you all, guys.
Good luck.
Good luck.
Bye-bye.
Thank you.